All right, everyone, thank you for coming out to part 2 of the Fast Case Work From Home Wednesday series focused on what on earth is happening in law and policy around the COVID-19 pandemic. So if you were here for the first version of this, you'll know that we talked about, for the most part, we talked about the C.A.R.E.S Act, because the C.A.R.E.S Act really represents the kind of crux of what has occurred in terms of legislative interference when it comes to issues around the COVID-19 pandemic. So before we dive into the meat and potatoes of what we're going to talk about, if you did not attend that first session and you would like a copy of that webinar, please send me an email. I will have my email address posted on the final slide. If you would like that and the associated reading materials, please let me know by reaching out to me directly. Second point of housekeeping to note before we dive in, as always, this is an informational webinar only. It does not qualify for CLE credit. However, as always, I promise that you will learn a lot. If you need CLE credit, you can always receive up to 4 hours of free credit by going to our webinar library at fastcase.com/webinars. We have a lot of great ones available in that library, including my personal favorite on Boolean operators. The last thing to note is we also, if you have not been consistently attending this series for Work From Home Wednesday, we do offer them every Wednesday at 2 p.m. Eastern Standard Time. And we have done another relevant series on business interruption, case law, and legislative intervention. So if you are interested in a recording and the associated reading materials, and I did send out a lot of reading materials for that session that are nice and dense for you, please also send me out an email directly on the email address at the final slide. Otherwise, my name is Ken. I am a reference attorney. I am here with Aaron, our head librarian at FastCase, and we're going to talk about what has really happened since the beginning of April through today in the world of law and policy around the COVID-19 pandemic. We're going to do this in really 5 big parts. We're going to talk about where we've been in terms of debt relief or disaster relief legislation. We're going to talk about the 5th bill that is likely going to get eaten up and adjusted, as politics will often do. We're going to talk about outside of the world of politics, what is happening in terms of case law, what is happening in terms of executive and agency policy in part 3. We're also going to end with Aaron talking about bankruptcy and legal proceedings in the new virtual, socially distant world that we live in. So with that agenda out of the way, let's start with reviewing the 4 debt relief acts that have already passed. On your screen here, you will see the names of the first 4 disaster relief acts that we have passed so far. And let's talk about an overview of them in turn. So first up, we had the Coronavirus Preparedness and Response Supplemental Appropriations Act. So this was really the first passage of what I like to call disaster relief light. Now, for a lot of people, they may think to themselves, okay, but this was a $50 billion disaster relief bill. So how can you say this is disaster relief light? Well, because it is, because we've spent about $4 trillion as of this point on disaster relief legislation. So this was passed in early March when people really did not have a clear understanding of the national impact of a pandemic, because that is how pandemics often go. When we've dealt with pandemics in the past, when we've dealt with things like bird flu, mad cow disease, Ebola, this is just what happens. No one can interpret, no one has a crystal ball that gives us all of the answers to the sort of, expanded impact of any type of disaster, pandemic or otherwise. So as a result, this did kind of lay the groundwork. It started by providing millions of dollars for things like disaster assistance loans with the SBA. It started laying the groundwork for funding for our public health agencies. It also laid the groundwork for our national disaster preparedness strategy. So that is focused on things like manpower for CDC regulations. It's focused on having a comprehensive communication network. It's also focused on things like those pings that you receive on your phone when a disaster is nearby relative to where your phone is situated. That is where that money goes. If you ever hear the term preparedness strategy, really focus on, that is really an odd way of saying a communication network. I wish they would just call it a communications network, but that is what it is when we refer to that. It also had the largest impact being it made medical visits covered by Medicare. So this was a huge policy change that a lot of proponents believe will remain in place. They believe that with the world of telemedicine and telehealth being what it is, that we will see policy changes like this for now and for the indefinite future. So with that, let's move on to Act number 2. So Act number 2 was really focused when we started to realize that, okay, well, this is spreading to all 50 states, and we have to provide some level of funding for sick leave. So the Families First Coronavirus Response Act was primarily focused on sick leave. So what this act does is it gave every person who was employed by an employer who has 500 employees or less, it gave them various types of protections for paid sick leave. So there is a cap on this sick leave. The sick leave caps the amount of pay that so with this act, I should take a step back. With this act, you are eligible to receive 2 weeks of full pay based upon the average annual hourly average, I think I repeated average twice, based upon how many hours a week you work, based upon an annual average is a better way of saying this. So if you were a part-time 20-hour-a-week employee, then you receive 20 hours of pay, up to 40 hours of pay total. We cap this at $5,110 if the paid sick leave is based upon you yourself being out of work due to you yourself having COVID-19 related issues. So if you go to your healthcare provider and your healthcare provider says, no, you tested positive, or you even are symptomatic for COVID-19, you need to stay at home for a period of time, the FFCRA would cover you up to $5,110. Now there is a different cap if you need to be out of work for caring for a dependent. Now, when you're dealing with dependent coverage for paid sick leave under the FFCRA, it is important to note, and this is arguably the most important provision to note because people get confused about this, have to have COVID-19 related symptoms or test positive for COVID-19 in order to receive the up to $2,000 paid sick leave that you get if you have a dependent. All the child has or the dependent has to experience is some level of interruption. So it could be that your governor has closed down your schools and you need to be at home to take care of a child due to school closures. It could be that your child care facility has closed down due to a stay-at-home order. These are classes for which this up to $2,000 paid sick leave provision would apply. So make sure that you understand that very clearly because, as I noted, there has been a lot of confusion, and that point has now been clarified by the respective government agencies. Now, there is also another exception. If you work for an employer who has 50 employees or less, there is an exception from the FFCRA that says that if meeting the requirements of the FFCRA would mean that your business could likely go out of business, you are exempt from the requirements of the FFCRA. However, this is not something that is proven just by the employer saying it would be so. The employer does need to be able to provide some evidence. If you are the employer, you do have to provide some level of evidence that you would essentially run the risk of being out of future business if you qualified with provisions from the FFCRA. The evidence level is quite low, but just remember that it is not just simply you stating that, qualify or paying out this money would jeopardize the viability of my business. Case in point. Moving on to the third. So the third act, as I noted, was the largest act. We had an entire webinar about the C.A.R.E.S Act. So the C.A.R.E.S Act was quite expansive in the things that it covered. So it did large things, like it provided every person who made $75,000 or less according to their latest filed tax returns, it gave them a $1,200 stimulus check. It also provided you with an additional $500 per dependent. It gave individuals things like payroll tax credits. So for example, if you were an employer and you were deciding to stay open, you are eligible to receive what we call a payroll retention credit, which will allow an employer who is paying out payroll during a time for which the COVID-19 pandemic is interrupting your business or disrupting your financial success otherwise, or streams of revenue, however you want to describe financial troubles. It allows you to receive on your next year of filed tax returns up to a 50% credit back for funds that you use to cover payroll. Now, if for whatever reason you did not qualify for tax credits or you did not want to go through this sort of reimbursement with tax credits, then we have the other big provision of the C.A.R.E.S Act, which was the Paycheck Protection Program. Now, the Paycheck Protection Program, while well-intentioned, has had its own series of issues. The number one being it ran out of funding quite quickly. In fact, some believe that it ran out of funding within a couple of weeks of the implementation of the Act. So what the Paycheck Protection Program has done, it allows an employer who does not remove employees. So if you are keeping your full-time employees on your payroll, so I believe the exact number is as long as you do not reduce your staff by more than 10%, you would qualify for a forgivable loan under the Paycheck Protection Program. This forgivable loan is up to $10,000 per employee, and it does provide provisions if you pay out funds for things like independent contractors, as long as you can prove, based upon a quarterly average, what you are paying out to 1099 employees. They do not have to be actual employees under the law in order for you to qualify for funds from the Paycheck Protection Program. You can also, depending on how your business is set up, you can also do things like use the Paycheck Protection forgivable loans to cover things like if you are in a partnership, to cover the direct funds you provide yourself while you are running your business. This is often something that people in smaller law firms run into, so that is often a relevant thing to point out. The Paycheck Protection Program is designed for people with 500 or less employees. Now, the biggest issue we talked about was, okay, well, I think that they've run out of funding or my loans are not being approved. What is happening? What are the issues? Why is there not resolution in sight? As I told people in the previous disaster relief webinar, at times the issue may not be that the program itself, because they have reinvigorated, or they have provided additional funds twice now for the Paycheck Protection Program. The issue is likely not that there is not enough funding to approve your loan. The issue may be that the financial institution that you are seeking your loan from does not have the approval to provide. They can only provide, in essence, a certain amount of loans. So I use Wells Fargo as an example. Wells Fargo, due to previous settlement agreements with various agencies in the past, is capped at the amount of consumer lending they are able to engage within, meaning that if Wells Fargo receives requests for $30 million in PPP loans, because PPP loans are serviced by independent financial institutions, they're not serviced by the federal government itself, you need to simply check an additional or another financial institution as the moral of the story, because it is likely a cap on lending ability, not the federal program is out of money issue. I guess, is the moral of this story. Now, the C.A.R.E.S Act also did additional outside of the PPP, because I could talk about the PPP all day. It also has removed withdrawal penalties for if you're taking out loans from your 401k program. It has alleviated those withdrawal penalties. It also has put federal student loans in forbearance until October of 2020. And then it really revved up the funding for our frontline workers, for vaccination developments, and last but not least, for things like suicide prevention, et cetera, et cetera. All right. So moving forward to the last but not least, number 4. All right, so the last one was really designed to just replenish funding for programs where money was dwindling, where we had structure in place, but we did not have the money to back up these various programs that we've implemented. So as you see on your screen here, we provided another $310 billion for the PPP program. We also provided another $10 billion for the Economic Injury Disaster Loan. If you are not familiar with the Economic Injury Disaster Loan, it is an add-on for a Paycheck protection program that allows you to receive another $10,000 forgivable loan advance on top of the money that you receive from the PPP program. That is just another pot of money that is, for all intents and purposes, allowed to be acquired if you still meet the requirements of the PPP program, which we'll talk about in additional slides. And then, of course, as you see on your other slide here, it provides things like $1.2 billion for additional vaccine development. It provided $825 million for our rural health clinics, and then it started putting into place provisions for contact tracing. So it did launch an additional $1 billion for the beginning of sort of policies and guidelines and technology for contact tracing for people that have tested positive for COVID-19. Moving forward. So now we have what we call the HEROES Act. It is our 5th debt relief bill that has already been passed in the House and is currently pending Senate review. So this really is another bill designed to not necessarily expand any sort of new developments in terms of programs, but just to replenish dwindling funds. As you see here, we're working on things like additional $1 trillion for our states. Now, the $1 trillion for our states are really focused on replenishing unemployment funds. Now, under the C.A.R.E.S Act, the C.A.R.E.S Act did give states the ability via federal funding to provide people unemployment coverage for up to $600 per unemployment applicant that was solely covered by federal funds. Now, for a lot of people, they get confused about this sort of unemployment enhancement. The unemployment enhancement is on top of whatever your state provides. Now, this $600 a week in sort of federal unemployment enhancement was designed to allow people, so things like our gig workers, so if you drive for Uber, if you are a solo practitioner, a self-employed individual, all of the people who traditionally would not qualify for what we think of when we think of state-covered unemployment is what this unemployment federal expansion, or what they call the Pandemic Unemployment Assistance provision of the C.A.R.E.S Act, was designed to implement. That is where the large majority of that $1 trillion is going to go. Now, we also will have a separate $100 billion that is going to be focused on educational stability. So as you know, our universities have been closing, our public school systems have closed, et cetera, et cetera. Due to all of the re-implementation that's going to be required when our public school systems and our universities return to sort of physical normalcy at some point, that is what that $100 billion is designed to implement. So it'll be used for things like if we have to expand, real estate. So let's assume that a 100-person college class now has to be in 2 classrooms versus 1 in order to do things like implement social distancing requirements that are in place even when universities reopen back up for physical, we'll call it attendance, if you will. It's also going to be used for things like providing internet connections and internet systems for people who are in public schools in rural areas, et cetera, et cetera. And then, of course, we have funds for things like our elections. We have an election coming up. This is going to be focused on implementing systems for things like mail-in ballots and things, and the security measures necessary to implement things like mail-in ballots and things of that nature. And then it's also providing a lot more funding for our PPP program and for vaccination development. So that is what our fifth bill is focused on. And as you see here, it's also implementing on the last line there, $75 billion for contact tracing, which if you remember from our previous slide, before the fifth sort of proposed act was in place, we had only allocated $1 billion to contact tracing for COVID-19. So, next slide, if you will. All right, so these are some additional provisions that we have because this was an 1,800-page bill. So some of the other additional provisions you see, we have another $4.7 billion for vaccination research. We eliminated cost sharing for our Medicaid beneficiaries. We've also provided hazard pay. So under the current proposed legislation, we would provide up to $13 an hour for increased pay for individuals who are working in places like our medical fields, people that are doing any level where there's a heightened exposure risk to COVID-19. There is a HEROES fund designed to provide them with what we consider to be hazard pay, which is a fancy name for saying up to an additional $13 per hour equivalent for each hour worked for those individuals that are deemed to qualify for said pay. Now, some people say, okay, well, does this mean that every person that was currently deemed essential would receive access to this HEROES fund? That is yet to be determined because they have not released the full explanation of who would qualify for hazard pay, but for the most part, it seems based upon sort of suggested guidance on the matter, it would qualify for things like our ambulance workers, our hospitals, our nurses, our doctors, et cetera, our EMTs, blah, blah, blah. And then the other big provision would be that it would, under the HEROES Act, families would be eligible to receive up to another $1,200 stimulus check per individual, up to $6,000 per household. And then it would also expand the federally subsidized unemployment expansion, which is currently cutting off at July 30th of this year. It would extend those access to that federal funding through January 31st of 2021. And then, of course, these are, like I said, slide number 3. It is also going to look at things like providing emergency assistance because, as we know, rent is still due during a pandemic, so it's going to provide things. It allocated $100 billion for assistance for low-income renters. It expanded our tax credits. So for previously, we were at 50%, and when I talk about the retention tax credit, when I talked about the C.A.R.E.S Act earlier, the HEROES Act would say, okay, well, we will reimburse you via tax credit for payroll expenses that you provide out. It would say, okay, well, we're now going to extend that from 50% to 80%. It's also going to be looking at ways upon which we can retrain people who may, let's say that you worked at a business that is never going to reopen due to, the sort of sad consequences of a disaster or a business interruption. It does provide $3.1 billion to assist in training people to pursue new careers. It also expanded access to the food assistance program via SNAP. And then, of course, it also clarified that the PPP program does include all nonprofits. There was currently a question about whether all types of nonprofits qualified under the PPP program, and the HEROES Act would clarify that as a matter of law. And then for those of you who are lawyers who, like myself, who may have student loan issues, it also provides for up to $10,000 in loan forgiveness for federal student loans. So PPP, as I said before, people had questions about how the PPP program, they would apply, and they were wondering, okay, why was I denied? Or they had questions about, okay, well, how do I calculate the amount that I'm seeking? Because at times, if you calculated the incorrect amount, they would push back your application and say, okay, well, this calculation is wrong. Or people would, let's say your business, you thought that you were eligible for $100,000 and you got approved for $15,000 and you were wondering, why on earth have I only been approved for this amount, et cetera, et cetera. The SBA, after enough prodding and poking, finally released expanded guidance. I will provide the full 4 pages of this additional guidance, as well as a hard copy, well, a digital version of the hard copy of the PPP application that was released in conjunction with this expanded guidance. But long story short, as you see on the slide here, the guidance really is focused on providing specifics around what is covered under the PPP program. So generally under the PPP program, you're provided with 8 weeks of payroll, so funds for your payroll, and you're also provided with the ability to pay out your rent, mortgages, and utilities associated with that time period as well. This is just designed to show you how those calculations are made. On the next slide, if you will. You will also see that they also tell you what would result in you not having the full amount forgiven. So the one big concern people have under the PPP program is, what if I did not make it clear originally, the entire amount of the loan you receive from the PPP program is forgivable. Now, you have to meet certain requirements in order for the amount to be completely forgivable. The basic requirements are this. You cannot provide payroll costs for an individual who makes more than $100,000. If you have an employee who makes $120,000 a year, you can only provide payroll equivalent up to the first $100,000. Another thing to note is you have to do the math correctly. If you have employees who only work half-time or quarter time or a third time, et cetera, et cetera. The last is you have to do 25% of the funds you receive can go to mortgage, rent, and utilities, but not a penny more. So when you are making your loan requests, you need to make sure that you do that math accordingly. So the application I will attach after the session and the follow-up email does provide you with a table in order to calculate that amount correctly. If you violate any of these very specific provisions, you will either, number one, get your application kicked back for further information, or you will, more importantly, risk having portions of your loan proceeds received not be eligible for forgiveness. The purpose of this expanded guidance is to make sure that is not an issue. So next slide, if you will. So moving away from sort of legislation, where we've been, where we could be, and PPP guidance, let's talk about case law. So one big issue people wonder about, if you've been reading the news at all around the COVID-19 pandemic, is you see that more and more people are suing their states for executive orders resulting in stay-at-home, or executive orders requiring people to stay at home. So in big news, Wisconsin Supreme Court became the first location in the country to say, well, stay-at-home orders can be valid as a matter of right, as a matter of executive authority, but they do have to provide, or they do have to meet legislation in place. So they cannot violate the Constitution. They can also not scurry around legislative channels. So if your legislative body in your respective state has said that in order to have executive authority in instance A, B, and C passed, you must follow these channels. Or if your state legislative body says, okay, well, executive orders cannot be passed on, topics A, B, and C. If a executive order did not follow those channels of statutory sort of mandates to the letter, there is grounds to overrule that executive order. This is what happened in Wisconsin. They said that the stay-at-home order that was passed was unenforceable because it failed to follow the rulemaking process as designated by the Wisconsin legislature, and thus could not be enforced. So next slide, if you will. So what does this mean for the future around litigation as it concerns? If you'll go back one slide for me. Where we're heading to next is we're looking at, okay, well, what does this mean for lawsuits as they pertain to executive orders? So what we're seeing in trends within these lawsuits against these executive orders is we're seeing, number one, they're being dismissed because courts are saying, well, at this point, because the executive orders are being relaxed, because people are slowly coming out of stay-at-home mandates, they say, okay, well, these cases are no longer valid because businesses are now free to pursue business as they were. Now, the other trend that we see is if a person is raising constitutional arguments, so if they're looking at things such as in North Carolina, there was a successful lawsuit against the governor's executive order as it pertains to the right of our churches to assemble. They say, okay, well, if you have, let's say that your executive order was eased and your entity did not qualify, those lawsuits have proven successful. So you really have to, when you're looking at the success of a lawsuit against an executive order, you want to focus on, okay, well, is there, distinctions between application? So is there phases in your sort of relaxing of a stay-at-home order? And let's say that the entity that your business, et cetera, your church, et cetera, is in phase 3. People have made successful arguments saying, okay, well, this is a violation of constitutional principles around equal application, around the First Amendment, and thus stay-at-home orders have not applied to entities that are in phase 3 or phase 2, but wanted to be in phase 1 is the moral of the story. So those types of sort of unequal application suits have proven successful, as North Carolina evidences, because while that was situated in the First Amendment, it really was focused on the fact that this category of businesses could open, but these churches could not. Now, on the flip side, if we're running into an issue like in New York, where there is an equal across-the-board application of a stay-at-home order that has not yet implemented phases, courts tend to scurry the other way. They say, okay, well, while we understand that individuals want to return to normal, we do give states the ability to use their police powers to implement regulatory schemes such as stay-at-home orders when the stay-at-home orders apply to everyone. So unequal application or the phasing appears to be the problem with how these lawsuits against executive orders will turn out, assuming they are not dismissed on grounds of mootness. All right, next slide, please. Another important thing is that the EEOC has now officially authorized the use of testing in the workplace. So if you are an employee of an employer who requires you to do things like have your temperature taken, to succumb to COVID-19 testing on site, people had previously been concerned around violations of things like privacy, intrusion, et cetera, et cetera. The EEOC has now said that under EEOC guidelines that on-site employer testing, whether it's via an actual COVID-19 test or it's via just testing for symptoms such as temperature, those are all considered valid guidance under EEOC authority. Now, this is particularly relevant if we have been paying attention to lawsuits against meat processing plants. So there's been rhetoric on all sides of the aisle around, okay, well, should meat processing plants stay open? Can a person sue? Can a person say, okay, well, I work for a meat processing plant. Can I go to court to do one of two things? To get injunctive relief saying that no, this business or this specific processing plant cannot stay open due to health concerns. Or number two, can I go to court and seek injunctive relief saying, okay, well, this business needs to follow certain steps in order to protect me, the employee, from health risks related to COVID-19. Now, what we know is from, as you see an excerpt on the screen, from a lawsuit that took place against Smithfield Foods in Missouri, what courts are doing is they are saying, okay, well, this is not a matter of court concern. We are deferring this to our government agencies. So we are deferring this under the primary jurisdiction doctrine, which essentially says that if we are dealing with issues that are under a specific highly regulated area, we defer to the agency for sort of direction on how to proceed. So that is why those EEOC regulations, the USDA regulations, or the guidance, et cetera, that we looked at on the previous slide have now become more and more important. All right, next slide for me. So moving on to the other issue is habeas corpus claims during a pandemic. So one other big legal issue people run into is what they're seeking legal relief. They're filing habeas corpus claims due to civil or criminal detention during a pandemic. They are essentially saying that there is no possible way that a detention facility is capable of implementing things like social distancing, increased disinfectant measures, hand washing. People are saying, well, there's no possible way under the sun that a detention facility can even meet a single one of the CDC guidance points for how to proceed, the guidance points that are essentially the final say, as we learned from the court proceeding in Missouri, on how businesses and entities should act during a pandemic. So starting with the Gomez case in New Hampshire, they have broken out sort of levels of detention. If you are in civil detention, so this often happens in people that are awaiting removal proceedings, in immigration settings, the courts have said that civil detention is distinctly different from criminal detention, and as a result, at minimum, people that are civilly detained in a facility where there is some level of evidence that CDC guidance points are not being met do have, at minimum, the ability to receive access to a bail hearing. Now, the court here does say that at-risk groups are even in heightened concern, but one does not need to be a member of an at-risk group in order to qualify for, at minimum, a bail hearing if they are in civil detention. So next slide for me. Now, an at-risk group is going to be people that fall into the following categories. So when we're talking about habeas corpus proceedings under civil detention grounds, high-risk groups receive almost automatic approval to receive access to a bail hearing or bail proceeding. These are groups that the courts have defined as being high risk. people that are pregnant, over 60, or have any of the sort of immune compromising disorders you see on your screen: kidney disease, heart disease, et cetera, et cetera. Now, for criminal detention, that is a whole different story. So for criminal detention, habeas corpus grounds are less clear. With regards to criminal detention, I focused on, for example, in the Fifth Circuit, there was a case that went up to the Fifth Circuit where the prisoners had refused to file a prison or a grievance with the sort of administrative bodies for the prison system. They instead went directly to file a lawsuit. The district court granted an injunction requiring the prison system to implement certain types of behaviors to basically coincide with CDC recommendations. However, the clarifying point is that the district court did not actually say, okay, well, these individuals in these facilities receive access to things like the ability to leave the prison system on grounds of bail proceedings, et cetera, et cetera. The Fifth Circuit went even further and said, okay, well, we hear all of what you're saying about this prison facility not following these recommendations, but they in fact stayed the injunction from the lower level court that required the prison system to implement certain types of behaviors. Then they sought a stay of this stay, or a removal of this stay, to the Supreme Court. The Supreme Court denied the application to rescind the stay, but at the same time provided an additional opinion laying out criticisms of the conditions within the prison. So all we're left with after the Fifth Circuit and after the Supreme Court guidance is the fact that it seems as if there's not going to be any habeas corpus relief, but there may be grounds for a person to have some sort of injunctive relief requiring a prison system to alter behaviors as it pertains to CDC recommendations within those facilities, is the moral of that story. All right, next slide if you will. Business interruption is another area we talked about before. Long story short, on our business interruption insurance, people are basically suing their insurance company saying that I had coverage for business interruption under my policies and my insurance companies are refusing to pay out. What we know about business interruption at this point is essentially nothing, because there's not been progress on a single suit under business interruption policies that has proven to provide us with guidance either way. I've laid out some of the additional descriptions of those cases, and I will provide you with relevant dockets in the follow-up email. So what we do know is it's not looking good for people that have filed business interruption claims against their insurance companies. And we've gauged that from the fact that there's been little progression in the sort of judicial resolution either way. There's also been federal intervention by the Treasury and by our members of Congress who have essentially said, okay, well, people not receiving payouts for business interruption claims is concerning, but we're not actually going to force them to just pay out directly. There was some hope when we talked about this discussion before about the fact that we may have some state or congressional intervention that would require an insurance company who had denied a business interruption claim to retroactively pay out a denied claim or be forced essentially by statute. Well, not a single one of those state acts has passed, unfortunately, and there was also previously a federally filed bill in Congress, and that also died. So what has proven to be a little bit more successful is going to be the Pandemic Risk Insurance Act. So this would give insurance companies federal funding to satisfy denied business interruption claims. And depending on the size of that insurance company, they would then have to reimburse the federal government over an extended period of time for proceeds that they pay out under business interruption claims that the insurance company would otherwise have denied under their policies. So this is seeing a little bit more traction. It has not completely died on the federal hill, if you will. But once more, it is not the insurance company directly paying out proceeds sort of on the private stage. There is a large amount of federal subsidization at issue, is the moral of that story.
Okay. So moving on to the Federal Reserve for just a moment, this is taking a slightly different task or actions than the Payroll Protection Program, the PPP. The Federal Reserve is taking independent action in our current COVID situation. Specifically, there is about $600 billion that are in a program available for those who do not qualify for the Paycheck Protection Program. This includes businesses that don't qualify because of the number of employees that they have, as well as other businesses who don't qualify for the various other exclusions that are under the program. These loans are not forgivable, but they are at a very low interest rate, so they are more attractive than the standard loans or the standard individual loans that these businesses might otherwise be qualified for. There are a couple of other regulatory actions that they've taken that have been seen as streamlining the loan process as well as streamlining the various bills that we've already discussed. This includes modification on the requirements as to how much money each of these federally insured depository banks have to keep accessible. This is part of the FDIC regulations to prevent runs on the bank and to prevent banks from loaning more than they are capable of maintaining. So these are semi-risky moves, but are increasing the liquidity in the market. Additionally, you heard Ken mention earlier that Wells Fargo had a cap on the amount that it could loan under the PPP. That cap has been expanded. So some of the loans that were initially not qualified or could not be processed under Wells Fargo now can be, but that does require that the entity seeking the loan go through the application process again. So if you have a client that's in that situation, it would be a good idea to double check with Wells Fargo and then return to the process of applying for those funds. Additionally, we have a couple of other measures, including the lowered federal interest rate that reduces the amount of payments that are necessary for that particular circumstance. And we also have an increased amount of collateralization available for certain smaller financial institutions. So this allows those smaller financial institutions, mostly credit unions, but a couple of other smaller banks and other financial entities, to make larger loans than they would normally be capable of doing due to the amount of their traditional collateralization, so that they can make those loans during these current circumstances. There's also a couple of restrictions that are unique to our current circumstance, and this includes the ability of banks to buy back their own shares. Again, measures aimed at reducing the amount of profitability that could come from this situation unexpectedly. Most of the Federal Reserve Acts are, again, aimed at increasing the amount of liquidity, but not in creating an unexpected windfall for the financial institutions. There are a couple of other acts that do appear to be in process for the Federal Reserve. However, they haven't released them publicly. There's been quite a few private acts that they've been taking under consideration. So the next Federal Reserve meeting should be very interesting. We'll see what comes up as a result of that. Speaking of bankruptcy, just quickly, there's a couple of provisions that have been very unique to bankruptcy. The first, of course, has been a part of the C.A.R.E.S Act. The C.A.R.E.S Act had a couple of definitional changes that heavily impact bankruptcies. So if you're filing a bankruptcy on behalf of your clients, do check to make sure that you have the current language in effect. The payments that are available under the C.A.R.E.S Act, those are those smaller payments, again, mostly dealing with rent and other emergency expenses. They are not defined as income under the 11 U.S.C. 101 10A B2. So they are still funds that your client can use to pay bills, but they're not defined as monthly income under those bills, so they don't have to be claimed under your statement of current monthly income. Similarly, they're also not considered to be disposable income. So if you're trying to make the determination if your client meets the requirements for Chapter 7 as opposed to a Chapter 13 plan, these funds do not qualify or not considered to be disposable income. This also is available for any debtor who has not finalized their Chapter 13 plan. So if you had someone who was already in the process of filing but had not finalized their plan with the trustee, worth going back and double checking and seeing your numbers to see if they could get a more favorable plan or if they could arrange their plan in a order that would make more fiscal sense for that particular client. Do keep in mind that this has a longer tail on it than some of the other provisions in the C.A.R.E.S Act. It's in play for a longer period of time. Also, just a quick note off of one of the things that was on the earlier slides, keep an eye out for some of the definitions pertaining to taxes. That's going to have a big impact on the payment of taxes for the entire financial year of 2020, which means that they're only going to see those coming into play in the calendar year 2021. One additional point as related to not necessarily bankruptcy alone, but bankruptcies and other financial filings, and this is mortgage forbearance. There have been requirements for mortgage forbearance in the past. However, the C.A.R.E.S Act has new encouragement for this action to be taken by various lenders. There are three major types of mortgage forbearance that are currently common in the filings, and these include the first type you see, type A, where a payment is due at the end of the forbearance period. So this would be a classical balloon payment. So just giving an example, if you received forbearance for the month of April, your payments from April would be due at the beginning of May. So it's not a very long forbearance period, and it does involve an immediate payment of the full amount that would have been otherwise due. The second type of forbearance that's currently popular, payments spread across a specific time. So if you received forbearance for a certain period of time, say 3 months, you would still pay that amount in that same calendar year, but the missing payments from those 3 months would be spread across the remaining 9 months of that year. So 9 months to a year is our typical time period. And then, of course, the third type is where the payment that has been foregone would just be added to the end of the loan. So if you did not pay in March, April, and May, at the very end of your loan period, 20 years in the future perhaps, you would have 3 more months of payments to make up the missing payments that have been foregone in this current time period. None of these methods is particularly approved or legislated in favor of. All of them are common in our current filings. And there's been over 200 notices for this type of mortgage forbearance in the courts in the last 60 days. So all three of these are currently very common. One quick dive into the case law regarding mortgages in our current situation, and this is again regarding the PPP. The original formulation and guidance given for the PPP indicated that if the debtor was involved in a bankruptcy process, that they would not qualify for the loan forgiveness under the PPP. You could not be in the bankruptcy process and receive PPP funding. This has already gone through the courts in the case that you see on the screen, Roman Catholic Church of the ARCHDIOCESE of Santa Fe, and the court found overwhelmingly that this was an arbitrary and capricious provision and ruled against it. So there is no limitation as regarding bankruptcy for someone to receive PPP funds at the moment. That particular guidance has been removed. Also, just a quick note regarding standing orders. We'll talk more about standing orders in just a minute, but there have been a number of bankruptcy-specific standing orders, so do keep an eye on that in your practice. These standing orders, of course, are regarding various aspects of a bankruptcy and dealing with them as individual to that particular court. But there have been a number of standing orders regarding signatures, again, whether they have to be wet or live signatures versus an electronic signature, dealing with virtual hearings in the bankruptcy process, adjusted scheduling of the bankruptcy process when the trustee will meet, when the plan will receive confirmation, things of that nature, and typically a removal of any in-person filing process with the clerk. So all transactions, of course, having to be filed electronically. Now, standing orders are more temporary than any of the legislation or regulations otherwise that we've seen so far, but do bear in mind that many of these standing orders apply until the court says otherwise, or until the next committee meeting or section meeting for the rules. So do keep in mind that you might need to check, even if it hasn't been recent, for standing orders that might still impact your client's bankruptcy situation. All right. A quick mini update on remote hearings, depositions, and trials. Many of the court's actions have been taken online. The screenshot that you see on the screen right now, that is of a Zoom hearing that occurred with the Supreme Court of Texas. Very dignified looking proceeding it was, in fact. But this is something that's coming up more and more as people are trying to deal with the restrictions of stay-at-home or of the phased freedom releases that have been coming along the pike. So just as a reminder for standing orders or the restrictions of a standing order, it's a forward-looking order that applies to all cases pending before a court. Depending on that particular standing order, it's going to encompass a specific issue or a rule that is being temporarily modified or changed. So again, a standing order is not going to be a permanent standing order, but depending on the jurisdiction, the standing order might stand until affirmatively removed, repealed, or otherwise replaced. Duration, again, temporary or until the next meeting of the committee or conference on rules, but be on the lookout for longer duration than usual due to cancellation of various committee meetings or conference meetings. Usually it affects one court. Sometimes it only affects a particular docket. So if a particular civil docket or a particular entity have as a rule applying just to that particular type of cases, or sometimes just for that particular judge. So again, do be on the lookout for those extra standing orders. They can have a massive impact on how you file, what you file, where you file it, all of the things that could be serious issues for your client. Speaking of video conferencing standing orders in particular, we've seen examples of all of the ones you see on the list on the screen. So pleas, sentencing, oral arguments, trials, literally anything that could have appeared before a judge usually has a standing order regarding it. The one you see on the screen right now, this is from the United States District Court in the District of South Carolina regarding pleas. In fact, encouraging situations or encouraging those who have plea arrangements that might be affected by the passage of time to do those pleas virtually and to accept those pleas virtually. So in a jurisdiction where perhaps civil actions have been canceled or have been delayed, as in Virginia or as in other jurisdictions, do check for a standing order for your particular type of motion or for your particular action, because even if the general court system has slowed or shut down, specific actions might still be possible virtually, and if you don't take advantage of those actions, again, it might have a major impact on your client. In addition to the standing orders, we've had a lot of action on emergency rulemaking as well. Again, these are the more permanent rules. There has been an invitation for comment on emergency rulemaking, specifically mandated by the C.A.R.E.S Act. So this would be impacting all federal courts, including the Supreme Court. That particular rulemaking period is still open, so if you have a comment or suggestion regarding it, I do recommend checking out that particular standing order and that particular session of emergency rulemaking. The one on the right-hand side, this is from Governor Newsom, specifically, again, mandating or giving greater authority to the California Judicial Branch regarding possible emergency orders, again, to facilitate virtual or non-in-person actions taken on particular court actions. So again, two branches there, both the executive and the judicial branch, cooperating to encourage virtual meetings and virtual sessions or virtual plea arrangements. And we're just going to touch on this really briefly, but there are some risks involved with dealing with virtual hearings. If you have questions about this particular type of situation, I do recommend checking out our webinar for next week. More about that on the next slide. But some of the risks that are involved with dealing with a virtual meeting, as you might have noticed, include the possibility of background sounds or background noises. The one that you see on the screen right now happens to be from the Supreme Court, where they were hearing oral arguments, and there was a distinctive flush sound in the background of that particular oral argument. But timers going off, kids, dogs barking, all of the above are a possible part of the background noise that can occur during one of these virtual sessions. And there have been several specific standing orders and emergency rules regarding decorum and behavior during these virtual sessions. My particular favorite one is the one that we named our session next week on. So I do hope that you guys will join us next time when we are looking into virtual conferencing and COVID-19. Can you at least wear a shirt? Which is, of course, going to occur on Wednesday, May 27th at 2 p.m. Eastern Time. Ken?
All right, I want to thank everyone for sticking around with me. This one went a little long because I hogged most of the time and said, this is the moral of the story about 20 times. So important takeaways. We've passed 4 debt relief bills. We have refilled the coffers for federal programs with the 4th debt relief bill. As a result, if you have applied for a PPP loan and been denied, or your financial institution is seeking additional information, either one, provide that additional information based upon the additional guidance I'm going to send out to you in the follow-up email, or reapply if your financial institution was perhaps one, if you applied with Wells Fargo, for an example. The other thing to remember from the Federal Reserve slide is that some smaller financial institutions were not providing as many PPP loans due to the Federal Reserve not backing or not collateralizing those PPP loans. The Federal Reserve just provided an additional $60 billion for that purpose. So reapply if you have been denied at a smaller financial institution or one with a cap. Business interruption, I did want to make one final clarifying point about that. When I say it does not look good, my intentions with that is not necessarily based upon pending litigation, because we do not know how those outcomes will be. It is based upon any sort of state or federal interference on that sort of level, or agency interference is not looking likely. The most we can hope for at this point is going to be the establishment of a federal program that will be subsidized for a point, or to some extent by federal tax dollars. And then otherwise, expect a follow-up email in the next day or so. And thank you all for coming out. Follow-up questions, kstrickland@fastcase.com. Take a moment to write that down. And with all that being said, I will not say moral of the story once more, except to point out that I won't say it once more. And we will see you next week.